they don't want to talk or involve them or follow whatever legal instructions are as board members from one subcorporation. I don't know if I'm being clear.
And the question you're asking now, who's looking to force them to do something different?
Well, me as an ex-board member, I try to inform them how to proceed, and we cannot, as a subcorporation, be over the association. However, they continue proceeding, making decisions on their own, and ignoring the association.
Well, unfortunately, in your position, there's limited options of what you can do. If you're saying they're not complying with certain provisions of the documents, that likely falls outside the scope of what the Division of Condominium deals with on its enforcement aspect. They primarily are involved in violations of the statute. In your situation, it sounds like you probably need to hire an independent attorney to put the board on written notice of whatever violations they're undertaking. And if they continue to ignore it, you will then have to bring legal action against them. It sounds like more likely a court action than an arbitration case to compel them to follow the documents.
Okay.
The only other alternative would be to recall the ones who aren't following the documents and put in board members who are more inclined to do what is correct.
Okay. Can the management company be responsible for allowing the board members to continue breaking the docs?
Well, the management company works for the association and follows the instructions of the board as long as it's not in violation of Florida law. So it sounds like the management company might be in a difficult position of having to do what may not be technically correct under the documents because the current board is instructing them to do that. There is the possibility that if they're in violation of their license, a complaint can be filed with the Department of Business and Professional Regulations about such violation if they're knowingly not following the documents and not advising what the documents require appropriately or getting legal counsel involved to provide proper legal guidance. That's more in the gray area and unlikely to be an actual license violation. So it's something to consider, but likely not going to help that much.
And I would just like to add, and thank you, Chigi, for the questions. I just want to remind, when questions get posed, it does give us an opportunity, and that's part of why I think you're all here is you may have questions, or at least you want to get information from that you're hearing from other questions. And one thing I want to remind everyone is, and Robert just brought this point up, the management company, like the legal counsel, is hired by the board, represents the association. And we both the management company giving their business advice and the law firm giving its legal advice, our job is to give guidance when asked for that guidance and when presented with. Ultimately, as board members, you're making the decisions. And so for those board members who don't agree with the majority board, or for those owners who are wondering why isn't the manager doing anything or why isn't the lawyer doing anything, you understand that our job is to offer the guidance when asked for that guidance. And same with the management team, they provide the guidance. If the board chooses to disregard or otherwise act differently, that isn't anything necessarily that a manager or an attorney can control. So thank you, Chiki. Let's go to the next one, Jeff.
Thank you.
Okay, let me just, a reminder too, for those of you joined a little bit late, use the raise the hand feature to ask your questions, not the Q&A feature at the bottom. Raise your hand. The next question is from the username Malcolm Sanderson. Malcolm, we enabled your mic. Please go ahead and unmute yourself.
Yeah, our association has placed a lien on a condo unit for unpaid association fees. The owner died, the unit went to foreclosure. It was purchased by a new owner. Is the new owner responsible for the unpaid association fees? Also, a hot water tank in the upper unit leaked down to the one below. Is the association responsible for repairing the drywall in that lower unit.
Okay, Malcolm, good questions. First of all, what community are you with? Just we asked, just if everyone remember, when you give your name, give the name of your association and whether you're a board member or not.
My name is Malcolm Sanderson. I'm with Bed Pine Community, and I'm on the board.
God bless.
That's right.
All right, so you asked two questions. The first question has to do with the association had a lien on a unit, and did you say it went to foreclosure through the association or through a bank?
It went to foreclosure. Actually, it was sold on the courthouse steps. I'm not really sure, but the court cleared it.
Right. Well, and the reason I'm asking, because if the association had gone to foreclosure and then it went to like a courthouse steps is now these online auctions. If it was an association foreclosure and a third party purchased it, they're going to be purchasing it for what the association is owed. And in other words, the association would be paid in full, and that would answer the question. If it was a lender foreclosure and the association maybe had a lien because the owner was delinquent, generally speaking, the lender foreclosure and a third party purchases at the lender sale, it's going to very much depend on the language in your declaration as to the responsibility of that third party. Florida statutes, and if you're in a condominium,
that's right.
Right. Chapter 718 does have what we know known as the safe harbor language. And that's where a lender takes title at its own foreclosure sale and is responsible for the lesser of 1% of the past 12 months of common expenses, or 1%. Pardon?
1% of the mortgage amount.
Right. 1% of the original mortgage amount, or, and why am I zoning on this, Robert? Fill it in. 12 months of the past due expenses. Typically, it's 1% of the original mortgage. That's the lender's safe harbor. That doesn't apply to a third party. A third party typically would be responsible to pay up whatever was owed by the prior owner, stepping into the shoes of the prior owner. However, it's possible that you have language in your declaration which might supersede that requirement and hold that. And in other words, if the language, what we call bad bank language, says that at a lender sale, either the lender or anybody purchasing it at the lender sale is not responsible for anything that came due prior to them taking title, that would mean that they don't owe anything to the association that the prior owner owed, and you'd only be able to collect from title forward. So it's important to know, if the association went to foreclosure and had a sale, you got paid in full. But if it's a lender, which seems more likely, then you need to know what your documents say, and you have to have your association attorney should obviously know that. And if you have language in your documents that isn't positive, you should be very much considering amending that section, and the entire community should be very much in support of amending that section so that going forward, the rest of the owners aren't responsible for past due expenses. It would be the new owner that's responsible. Rob, okay.
Can I sum that up and say that, if it was sold on the courthouse steps, then the new owner would be responsible for the past association fees.
Could be, Malcolm. Again, if it's a lender sale and it's sold on the courthouse steps, which is these online auctions, it depends on the language in your declaration. The language in your declaration of condominium would have to be reviewed to ascertain whether the third party can be held responsible for monies that came due prior to them taking title. Unfortunately, there's a lot of old language in these original documents that exclude them from being responsible for any monies owed prior to them taking title. Something that, quite frankly, as a firm, for those of you hopefully on our email blast list, we send out these articles, and several years ago when there was a court case that clarified this, we'd been encouraging all of our clients, and even prospective clients, as I call them, to update your documents to avoid this going forward. We still see almost every week, we see at least one community that we work with that hasn't done this, someone who's come over new to us, for example. And so I encourage you to have your documents looked at. If you don't, get with your counsel or find counsel you can get with to review that and give you that firm opinion as to what you're able to collect. And if it's less than the full amount from a third party, you should consider doing an amendment and follow your amendment process to get that fixed.
Super.
All right, second question, Robert, you want to take the hot water leak?
Yeah, the hot water leak.
Can you repeat it for me?
Yeah, the unit owner in the upper unit, the hot water tank burst, went down and destroyed the unit below, and the drywall needs to be repaired. So the people in the bottom unit are saying that the association is responsible for fixing the, and I think that goes back to what the documents say. But the documents really don't speak to it.
Well, the documents will identify maintenance responsibilities. Presumably the water heater is going to be the unit owner's responsibility if that's the source of the leak.
Right.
You need to determine whether or not that the resulting leak was due to the negligence of the upstairs owner, if it's just something that happened, whether it was a long-term leak or a sudden occurrence. A sudden bursting of the hot water tank would more likely be an insurable casualty event that triggers association and insurance involvement and association maintenance obligations that are much greater than your documents typically require. If it was not considered a casualty event and it's more of a maintenance related issue, the association likely has responsibility for the drywall on the perimeter walls that surround the unit and the ceiling and nothing else. And the unit owner below would have responsibility for most everything else that was damaged within the unit. So the cause of the water release is important to determine first. Whether or not you have to go to insurance, it may be less than your deductible, so it wouldn't necessarily amount to an insurance claim. If it's a casualty event, then the association likely has to do all of the repairs, except for those specific items that the unit owners are responsible for: the wall, floor, and ceiling coverings, their personal property, cabinetry, and things of that nature.
But how
So
do
you need a little bit more information for your ultimate answer.
how do you determine whether, because the upper unit was not there, they're snowbird and they just found out about it. So is that maintenance or is that negligence or?
Well, it could be negligence if they're snowbirds, they're away, and they didn't make arrangements for people to periodically be checking on certain portions of their units. If they didn't empty the water heater, turn it off before they went away, or do something that would make sure to protect this from happening, that could be considered negligence that would make them responsible for the damages that occurred from the water leak. So, you know, the facts and circumstances of the initial cause of the water leak is key to where everything goes.
And I would also just add, if you haven't, as a community, if you haven't adopted rules regarding what owners should be doing when they are not going to be in the unit for extended periods of time, like Robert just mentioned, with regard to, I don't know, draining your water heater or something, but addressing AC temperatures and addressing maybe turning off the water, things of that nature, then that's something to consider. You can, if you work with council, adopt good rules with language in those rules that indicate if an owner doesn't do these things when they leave, and damage occurs as a result of their failure to do it, that would be considered a negligence on the owner's part. That would just give the association further support to a claim that the owner was negligent, which caused the damage.
Very good. Thank you very much.
Thank you, Malcolm. Who do we got next, Jeff?
Okay, next it is going to be username Wendy Craver, but just in case, please repeat your name and your association and what type of association. Wendy, go ahead.
Hi, my name is Wendy Craver. I'm at the Royal Saxon Inks down in Palm Beach. And I'm a board member, plus I'm chair of the Health and Safety Committee, which is something we put together, a committee we put together about a year ago, a temporary committee. I read one of your emails, I believe, this week about selective enforcement, and something has come up that our committee is not recommending at this point, but people are asking, can we allow vaccinated people to play cards in our social room, although people who are not vaccinated walk through the social room to the pool all the time, use it for Wi-Fi, they use it for computer use, printing, to read, and we're just not real wild about that. And would that be part of your argument of selective enforcement, that we only allow vaccinated people to do this, but not vaccinated people. That's a tough.
Yeah,
I know.
it is, and first, and the other thing I want to add, which I failed to say up front, is, with hopefully everybody is healthy, staying healthy. We're hopefully, a year ago, or almost to the day, is when all this proverbial stuff hit the fan. And hopefully we're seeing the light at the end of the tunnel situation. And as Wendy mentioned with the vaccines, I'm hoping, that people will make their own personal choices, but if you can get vaccinated, I hope you will. And Wendy, I don't know, the situation you raised, though, I guess it does raise some questions. Do you allow the card room to be used at this time? Has the board adopted rules that prohibit the use of the card room, or limit
Yes.
the use of the card, prohibiting the use of the card room?
It's actually called the social room,
Mhm.
and we allow 6 people in there at a time, for Wi-Fi and computer use only. No eating, drinking, or card playing.
Okay, and so the question becomes, hey, can we modify that rule to allow people who've been documented as vaccinated to use the card room or social room?
To use the social room,
In
even though.
addition to those other 6 people?
Say again?
You said, do they count as the part of the 6 people?
Yes, they would count as the 6 people, for the 6 people.
Yeah. I don't know that I don't think it's a selective enforcement situation. I think it's just a matter of, uniformly enforcing rules. I want to remind, in Palm Beach County in particular, there was a repeal of all orders, other than the facial mask covering, and so there is still an obligation, even if someone's been vaccinated, that there is still an obligation for facial coverings within the common amenities. And so I think I don't know that just because someone's been vaccinated, they shouldn't have facial coverings. And then there's and social distancing is still something to be considered, as well as cleaning and sanitizing. I don't see, you pose this as a selective enforcement. I see this more as the ability to, it's the board adopting rules that are reasonable. And so I guess the rule, and that would be something you'd want to review with your council to ensure that the rule that you're adopting would be seen as reasonable and not be arbitrary in its application. And the reason behind the rule saying, hey, if you've been vaccinated, we'll allow you to sit in the room. Someone walking through who's not been vaccinated, that doesn't necessarily, in my opinion, have an impact per se. It's just a matter of you're limiting use to 6, and so I don't know if that means do you have time frames within which these 6 people can be in there? And so, because what I'm trying to understand is, if someone wants to come in and use the Wi-Fi, do they have 30 minutes to do that? And then if you're saying, but
No.
these people, so if 6 people, it's the first 6 people in, they can sit there all day?
Yes.
Okay. I mean, and I don't know what kind of push. So I don't see this as I don't see the fact that these people have been vaccinated and you're allowing them to sit in there as part of the 6 as changing anything, unless I'm missing facts. Robert, do you have anything more?
Well, the CDC guidelines that have recently been released do give the indication that fully vaccinated people, meaning those who have been vaccinated and have had more than 14 days after their second inoculation, or with the J&J, the first one, can be together without masks in certain situations, but it still recommends in closed room situations such as restaurants or your social room that you still require mask wearing when not eating or drinking. So that could cover the issue. And from the point of selective enforcement, it's important to remember that selective enforcement is a defense available to owners who are subject to enforcement actions. So while what you're doing may seem that it's different for different people, it's reasonably based, and your enforcement is not, there's no enforcement action actually occurring. So selective enforcement isn't an issue unless you find yourself in a court setting. So I just want to clarify on that point.
I guess they're looking at it as they can play cards without masks.
Well, they probably can, based on the guidance from the CDC, but whether or not that's actually safe or desirable is still an open question. So would it be reasonable to tell them, no, you still got to wear masks, we'll let you play cards, but you got to wear masks and other people are coming through? I think that would be a reasonable middle ground for you to go
Okay.
with.
Okay.
I also
If
think
they
you
want to
should,
play together without masks, go to a unit.
right.
Well, that's the options that we give them, that they can get magnetic cards and play outdoors underneath an umbrella, to playing in their units unmasked. You know, it's their responsibility. We don't want the responsibility as a condominium co-op.
Agreed. And I'd say, I guess I'd summarize it with this way. In my opinion, the fact that someone's been vaccinated in this example you've given doesn't remove their obligation to be masked when they're in a common area of the private community.
Okay, thank you.
Thank you, Wendy. Who we got next, Jeff?
All right, thank you, Wendy. Next, we have a gentleman named Robert. Robert, please give us your name, association, and association type.
Yeah, hi, my name is Bob Horowitz. I'm with Abaco. We're an incorporated condominium village inside of a community called Winmore. And my question follows Wendy's, actually. We're looking to open up the community common rooms of Winmore. And we're told that limiting them to only vaccinated people would be selective enforcement. The CDC guidelines that were just mentioned say that vaccinated people can associate with other vaccinated people, not with non-vaccinated people. And we're told that would be selective enforcement. That goes for all our card rooms, all our game rooms, and our main pool complex.
And who's telling you it's selective enforcement?
Say that again?
Who is telling you that?
Our council and our administrator, council president and the administrator.
So not an attorney is what I'm getting at.
Well, I wouldn't say an attorney did not say that to them.
Well, again, selective enforcement, as I've indicated, is a defense, not an affirmative cause of action that somebody can say, hey, you're selectively enforcing, you can't do that. There are other legal concerns, such as a case law that provides that the board cannot create two classifications of owners and treat them differently by rule. Vaccinated versus unvaccinated is an example of two classifications of owners, and treating them differently would be allowing vaccinated to congregate in an area but unvaccinated cannot. That being said, these are extremely unusual circumstances. So the normal rules and legal principles that we apply may not necessarily be applicable to your situation. It's certainly a reasonable requirement that only vaccinated people can congregate in an area and unvaccinated cannot under the circumstances. So selective enforcement, I think, is an overstatement for these specific issues, but it also makes sense to still require mask use when anybody is in the common areas until such time as governmental agencies no longer require it.
I mean, that in itself,
Go ahead.
just the idea of requiring masks is almost the same thing as requiring vaccination, especially considering that we set up our own vaccination stations here and gave free vaccinations to all the residents who wanted them, who were over 65.
And you're also in Palm Beach County, correct?
No.
No, Winmore.
And
We're
you're
in-
Palm
No,
Beach
sorry.
County.
Hey, Bob.
How you doing,
Bob?
Bob? How you doing?
Yeah, Bob. The first, well, and just guys, everyone listening, and as Robert pointed out, we're not going to be able to give you hard and fast answers to these questions. I mean, these COVID related situations, and now, you know, for a year, a lot of you had heard, you know, Robert, myself, and Jeff Rembaum and I had done a lot of webinars, and some other attorneys in our offices. We've done a lot of these webinars about COVID and the situations with closing amenities and now reopening amenities. And now with the vaccine, it's a whole new wrinkle. You know, and this is all case of first impression, hopefully never again impression. But, you know, and we're kind of reading some of the same stuff you are, Bob. And as far as I'm aware, when it comes to the vaccine, what they're saying now, if you've been vaccinated, it's okay to be in your home with other vaccinated people, unmasked. But outside in the common areas, you should remain masked, because you don't know who, it's still unclear as to whether even if you've been vaccinated, that doesn't mean that there's not something that you might pass to someone else. I'm not saying I believe or I agree or don't agree, but it is what they've said. And I think Robert is very correct in suggesting that if you're outside in the common areas and you can't social distance, masks should be required. If you're social distancing outside, well, that's something even the county orders have said that it's okay not to be. But the county orders in Palm Beach and Broward, and I believe Miami-Dade, all still have facial mask covering requirements when you're inside, or if you're outside and not socially distancing, and that's regardless of whether you've been vaccinated or not.
No, I understand that. I was using the mask analogy to say that requiring some people to wear a mask to enter a facility is the same thing as requiring a vaccination to enter a situation based on the CDC guidelines.
Only in the extreme. There's a big difference between a mask and a vaccination. I'm sure you're aware.
But the CDC says that in enclosed areas, vaccinated people should only associate with other vaccinated people.
That is currently what they've said, yes.
Current knowledge that they have, yes.
Yep.
So you would say that we can enforce such a rule?
Yes.
I would say, Bob, that your best bet would be to have your APICO's general counsel review any rules you're considering, and any pushback that you might be getting from when the community council, ask them to put something in writing that explains what they're objecting to, and it can be reviewed.
Actually, it's the opposite. It's the community council that's talking about opening community facilities. ABICO has its own rules, and they're not being challenged.
Okay.
The other thing is going back to the inside kitchen walls for floods. I think it was mentioned that just the outer wall in with the responsibility of the owner. What about inside walls where there's plumbing, piping? Are those considered part of the common area?
It's going to be document specific, Bob, and that was what Robert had said. I mean, when you're talking about, guys have questions regarding leaks and obligations and responsibilities, these are very document specific. What we can say from the legal perspective is it is one of the first determinations is this an insurable event, or is it a maintenance related event? Meaning, is it insurable or not, or not going to be considered as an insurable event? Because then that's kind of like if you're looking at like a bubble, insurable, yes, no. And if it's yes, you're following one path. If it's no, you're following a different path. And then you're reviewing the governing documents to ascertain what the association's responsibilities are versus the owner's responsibilities.
Okay, because
Right.
a question again is boundary. I think our documents say from the paint in is the responsibility of the owner. The question is, are the inside walls where pipes come, like for instance, kitchen walls, are those a responsibility inside those pipes? Are those pipes the responsibility of the association or the owner? As far as insurance is concerned, our documents require all owners to have homeowners insurance.
Right, but that's not, but the issue becomes the interior, generally speaking, the definition of a unit. If the interior walls are inside the unit, then often that becomes the owner's responsibility under a maintenance situation. But if it's an insurable event, the statute says that if the inside wall is something that's original, meaning an owner didn't install it themselves, if it's an original, then it comes under the association's responsibility to address under an insurable event, which is why that's why I explained how we have to address it. Is it insurable or not? And then what are the documents? How do they documents define a unit? And even when they define a unit, do they then carve out under maintenance obligations that the associate, notwithstanding this is part of a unit, the association will maintain these pipes because they service more than one unit, for example. So it all has to be, it's got to be reviewed by the documents. You cannot just, anyone giving you a general answer saying this is the way it is, isn't giving you good advice.
Okay, great. Now we have a job for you. Good.
Well, that's fine.
We'll talk to you further on it, Michael. Thank you very much.
Thanks, Bob. You're welcome. Who's next?
All right, next, Lenore. Lenore, your full name, association type, please.
My name is Lenore Orlovska-Warren, and I'm in Ecoton Estates here in PGA National.
Hi, Lenore.
Hi.
What's your question?
Okay, I have a few quick questions. A year ago, I worked with Jeff Rembrandt because we had a problem with our election where the board just decided to give out proxies and say, these are the people who are running, and anybody else who wants to run, throw your name in the hat later. So we got them to stop the election and to start a new election. And we were supposed to have the election by the end of June of 2020. And our president just made it go away. We never had an election last year. And I was wondering, one, is this legal?
Is it legal not to have an election?
Yes.
Unless your governing documents provide that the election doesn't have to happen annually, then if the documents say there's an election annually, an election meeting should at least be noticed annually. In an HOA setting, as you know, there's quorum requirements, unlike in a condominium election. In an HOA setting, there's typically quorum requirements to hold the meeting at which the election will occur. And if quorum is not met, and I'm speaking in general, there are certain exceptions, but if quorum is not met, then there is no meeting and the board would roll over. That would not place that association in violation.
Okay, and then I'll check my documents now. Next, some board members, because of last year, served now 4 years. If they get reelected, and how they're saying in their advertisement, 3 board members will serve 3 years and 3 will serve 2 years. We now have 6 board members. And I'm wondering, those that already served 4 years, should they not really only serve 2 years, or does that go to your documents?
Well, typically, they would have been up last year and would, if they got reelected, would have served 3 years from that point, but that didn't happen. And in all likelihood, your documents will provide that the board members hold office until their successors are elected, and usually in conjunction with the annual election. The issue isn't necessarily the individuals, but the board seats. So what we see typically is that when you're dealing with trying to have a staggering situation and then fix where you got out of sync, oftentimes they'll have the top 3 vote getters will get the 3-year terms, and then the next 3 vote getters will get the 2-year term. It would seem that that's a reasonable way to go, although others have gone the opposite. The top 3, because they don't want to punish them, will only get a 2-year term, and then the lower 3 vote getters will get the 3-year terms. But more often it's the other way around. So think of it in terms of the seat as opposed to who's currently sitting in it. And the fact that they may be serving all these extra years is not really a big concern.
Okay, thank you. Next, as I'm a candidate running again, and they messed up things again, but what I would like to know, can a candidate for the board of directors request the following? How many ballots were received and how many votes cast? Because I'm looking at the fact that I think the ballot box is being stuffed.
Are you asking for that before the meeting or after?
Well, what happens is every year, and I'll be honest, I wasn't thinking, they just said, oh, we don't want to say how many people got how many votes. We're just saying that, Tom, Jenny, and Peter got elected. And they never say how many votes they got, and they've never said how many votes have been cast. And I'm wondering with this election, if I can raise my hand and say, okay, I didn't get elected, but I want to know how many ballots were cast, and I want to know a total of how many votes were cast. Can I do that?
You can do that, and whether or not they'll answer the question is a difficult point as well, because if they say, no, we're not going to do that, and you're not going to raise a stink and interrupt the meeting and cause, you know, a big uproar, I wouldn't recommend at that particular junction. But the record should be available for you to review after the fact. They shouldn't be disposing of them until you've had an opportunity to review them, and you would get that information in that way. So you make a written request for access to the official records to review that portion of them.
Okay, thank you. You answered that question. Okay, no one on our board has ever been certified. Is this legal?
Well, technically, all board members are required to either sign a paper that is available on the website of the Department of Business and Professional Regulations that says they have looked at the documents and will abide by them, or maybe not looked at them, but will abide by them, or take a certification course. And if they don't do either, then they're considered automatically suspended from the board until such time as they do.
Okay,
Not
so you go
removed,
back
but
to this.
suspended.
Okay, so you say, sign this paper. What is this paper called again, please?
It's a certification form, and it's available on the website of the Department of Business and Professional Regulation.
Department of Business, and okay, I'll look that up. Also, our manager claimed that, oh, I can certify anyone on the board. I just give them a workshop or whatever. Is this true?
He'd have to be certified by the department in order to do that.
Right.
And in all likelihood, he's not. But if he has the form, he can give them his version of the class and have them sign the form, and that would satisfy that requirement.
Thank you, Lenore. We're going to move on
Okay.
to the next person.
Okay, thank you.
Okay, next we have Michelle, and please, just in order to allow as many attendees to ask questions today, we have quite a few in the queue. Please, we're requesting that you limit it to one question. So, Michelle, please go ahead.
Okay, can you hear me?
Yes.
Okay, hi, my name is Michelle Harris. I am newly on the board at Whitehall, which is a condominium, about 163 apartments, and I'm taking on the role of treasurer. So my question is, what is the current thinking regarding condo associations and applications for PPP?
Your question is about what are the requirements for an association to apply for a PPP? I am not very familiar with the process for an association. I'm not even sure. There was a lot of debate as to whether an association would even qualify for one.
Yeah, so the question is about eligibility.
Yeah, I know that there was a debate about whether an association is eligible. You have an association attorney that I would say that's a question that would have to be directed to them, and they would have to do some research to investigate on your behalf.
Okay.
All right, sorry about that.
That's okay. Can I ask one quick question?
Well, since we didn't have an answer for that, we'll give you one question. Go.
It's a yes or no one. Are condominium associations required by the statute to have a website? And in our case, we have something called Building Link, which is not available to the general public. Does it satisfy the rules?
Did you say you're in a condominium?
Yes.
And you said how many units?
163.
Is it one building?
Yes.
Okay. So yeah, you are obligated to have a website, and you're saying you have a building link. Again, that's a good question, Michelle. I guess it would be a matter of ascertaining if Building Link is comparable to the website in that it's got all the statutory requirements that are necessary for a website. And in order to confirm that, again, in order to make sure you're in compliance, You should be, this is something you contact your manager. If you have a management company, don't burden them with giving you legal advice in this regard. Ask your association attorney to confirm in writing, hey, this is what we're doing for our website requirement. Are we in compliance with the statute? And get something. This way the board has a legal opinion upon which they can rely if someone was to question and challenge their business judgment.
Thank you very much.
You're welcome, Michelle.
Okay, next, Tony. Tony, please state your name, association type. Tony, please unmute your mic. You've been enabled. There you go.
Okay. Hello.
Thank you. We can hear you.
Okay. My name's Tony Yost. I'm a board member at the Greens in Tamarack. We have a out of control cat and kitten situation associated with a single unit, and the office staff seems to be stumped on what to do next after the person has refused to do anything about it.
What is the specific problem you're having?
They're allowed to run loose, and the smell in the area is bad. There's like 30 cats and kittens, all associated with one unit.
Well, if there's a nuisance that's coming from the unit because of this condition, we need to know what your documents say relative to your enforcement powers, but generally speaking, you would have to bring legal action to cause the owner to eliminate this problem. If it's removing the large number of animals from the unit, that's a possibility, or it might just be keeping it in a more clean and quiet condition so as to not cause a nuisance to everybody else. There are options you can pursue, but they typically involve legal action, lawsuit or arbitration.
Okay, thank you.
Thanks, Tony.
Okay, thank you.
Okay, next question is from Joseph. Joseph, you've been enabled. Please unmute and name, association type, please.
I'm Joseph Bitton. I'm a board member of Palm Lakes Condominium in Margate, and I'm in Canada. The border is locked, and I cannot go to Margate until they reopen the border. Now, what happened is that the president has replaced Zoom meetings with in-person meetings without consulting the board members and without providing an alternative option like Zoom to myself as a board member and to the homeowners. Is that legal? I'm in Canada and my voice has been canceled during the election and before that, during Meet the Candidates, and that's the problem.
Okay, well, I mean, I'll start and then Robert, you can jump in. The situation there is the association, and you're saying the president. So again, in my opinion, decisions should primarily be made by at least a majority of the board. It shouldn't be a single director making these types of decisions for the community. Obviously, the president does have certain day-to-day operational control, but in dictating how board meetings are to be conducted, it should be at least a consensus of a majority of the board. Board members may attend board meetings virtually or conference calls, so long as if it's a conference call, there's a speakerphone so that anyone present at the board meeting can hear that the director on the speakerphone, and the director can hear everybody else. It is not a mandate, though, to my knowledge. And as far as members, there is no requirement that members be given that same call-in option for a board meeting. Members are entitled to attend, and if the board is holding its meeting in person, then members are entitled to attend in person. You obviously still have a situation where you're supposed to, if the meeting's being held inside, you have social distancing requirements, you have facial covering requirements, and so these are factors that also need to be considered when you're conducting these meetings. If you're holding them outside, then those are a little bit more relaxed, but you still have certain requirements. So, Joseph, the situation presents, it's really a determination. If the full board or a majority of the board is saying, hey, we're going to hold board meetings in person, we're not going to have any board members attend otherwise, that is a decision the board can make. Of course, if you have a director friend on the board, you can simply call their cell phone and you can be on their speakerphone on your phone as well. I mean, that is something that can work. But there is no mandate that a board director be allowed to attend virtually. That said, if they're holding meetings and you are unable to get back there, it seems reasonable to me that your desire to be there should be welcomed.
Exactly. Exactly.
My thoughts on it, Joseph, is what you've described is more a political issue than a legal one.
Exactly.
And you probably need to be more in communication with other unit owners within the community to perhaps
or just fellow directors or the other directors first.
Right, but it sounds like a majority of the board may be in support of the concept based on nobody objecting.
Well, no, there are three out of 7 are objecting, but we weren't even consulted. It was just a surprise.
Well, unfortunately, 4 controls. So as long as the majority of the board is supporting what the president is doing in this respect, then it's going to take political action with the unit owners. And that ultimately can be resolved through possible recall of those who are acting in that fashion, or at the next election, replacing them with people who are more like-minded with you and your group.
But is there a law now that says that they should provide an alternative option because of COVID to
There is not.
In addition to in-person meetings, but he's not.
There is no law to that effect. Practically speaking, they should, but the law does not require it.
Not currently, Joe. Thank you, Joseph.
A document that, it was a lawyer's opinion that said that there was a law in 2020 by the governor to provide, at first, you couldn't have meetings, it had to be virtual, it couldn't be in person. And after, they should provide one and the other.
No, what the law allows, and quite frankly, there's legislation pending this year to clarify that virtual meetings may be held, but it's not a mandate. Okay, the law has allowed for years that board members may attend board meetings video, like FaceTime or conference call, a speakerphone. That's been in the law for years, but it's not a mandate that it be permitted. That said, like I said, it's a political situation, and that's something, unfortunately, that the law doesn't support one way or the other.
But when it was illegal, there had to be some other option, alternative, if they have goodwill.
Okay. I'm not sure that it was ever. I'm not sure what you're saying was illegal.
Yeah, they didn't allow stores to open. They didn't allow certain gatherings. They didn't allow churches to have more than a certain number, and then it improved. But that's slightly apples and oranges to the situation. Just focusing on your question. Hey, the board's holding meetings in person. They're not allowing other directors who can't get there in person to attend virtually or by speakerphone. And while Robert and I both agree that doesn't seem it's not something I would say to my client that's a good idea if they were to ask. But from a legal standpoint, it's not anything that is it's not anything, in my opinion, that could be legally challenged. It has to be something that you would address, hopefully internally with the directors, and let them see reason, or address it through the community. Would that be considered as bad faith on the part of those who do it?
Again, I don't know what their purpose or reasoning is, so it would have to be something addressed internally with them. Okay. And again, if you guys have association counsel, you should communicate with your association counsel, and if not, then you guys should seek association counsel and get some guidance.
Thank you.
Thank you, Joseph.
Okay, next we're going to move on to Thomas. Thomas, name, association type, please. Thomas? Going once, going twice. All right, Thomas, we're going to have to go to the next person. Eleanor? Eleanor, go ahead and unmute.
Okay. Can you hear me?
We
Yes,
can.
ma'am.
Hi, Eleanor.
So, Eleanor Saunders from Rainbow Springs Property Owners Association. And I'm just a homeowner here. We have a situation that's happening right now with another homeowner. And we have attended a few meetings. We have heard that if something is not specifically listed in your CCRs, that you can't get a violation for it. In this case, the homeowner has a trampoline and swing sets in her yard. There's nothing in our CCRs that say that you can't do that. But she's getting a violation for it. And they're giving her a violation under our statute that is temporary structures. Am I right in assuming that if it's not specifically listed, you can't get a violation?
Well, that sounds like whoever has identified the violation is being creative by tagging the temporary structure restriction. You need to look at the specific language of what's defined as a temporary structure to see if these items fall within that. There's a good likelihood that they do not, but it's hard to say without seeing what the documents say. The trampoline is certainly a temporary structure, and if the board wants to hang their hat on that and she wants to fight them on that, it's hard to predict which way it'll go, but I'm thinking it leans toward the homeowner than the association based on the facts you've described, but you know, at this point, it's merely a guess.
Yeah, we're very large. We have like 3,200 properties here. And if you drive around, you can see trampolines and swing sets and all kinds of stuff all over the place. So, you know, she's bringing up selective enforcement, but, you know, it's very hard to give everybody a violation because we're so large. But
Well,
do you
being
think
hard
that
isn't,
that would fall
being
into
hard
that?
isn't a defense. They still have to do it. If they want to be able to enforce, they have to do it uniformly. And so she needs to document the other substantially similar violations and able to defend herself if it goes to a more formal. When you say they're violating her, how have they done so? Is it just a letter, you're in violation, or have they implemented a fine? Or
Well, right now right now they just gave her a letter because that's our procedure. First give them a letter, and if they don't cure it, then she'll be up for a fine. Then it has to go to the fine committee.
Right. Well, and Eleanor, good question, because again, and for those of you listening, obviously, I think this is, I imagine a big part of why you're listening is you get a question like this, and it really is something that can apply uniformly to all communities. And, you know, whether you're 5 units or 5,000 units, to Eleanor, to Robert's point, is in order to, it's important that you're uniformly enforcing your covenants in a timely manner. In fact, we do a program, and our program focused strictly on enforcing covenants. And the next time that class is offered, you'll get an invitation. I would encourage everybody who's interested in has these questions about enforcing covenants and how the do's, don'ts, and the best practices and policies to certainly join that program. And it is something that you want to also have experienced counsel working with you to make sure that you're crossing your T's, dotting your I's. But you know, if you're sending her a letter and she's saying, hey, there's a bunch of these people who are also in violation, and you're not aware of these people, then you could certainly go back and ask her to please provide you the names or the addresses of where she's claiming these other violations are, so that the association can investigate. And then you go investigate, and if there are violations, those people need to be violated the same way. You know, it's not only do you have issues of selective enforcement, depending on the people who are being violated, I've seen allegations of discrimination. if the person's in a person of a protected class, even though that has nothing to do with it, they make those claims, and that's a whole nother ball of wax the association has to deal with.
Yeah. Okay. I thank you very much.
You're welcome.
Thank you.
Okay, we're going to try Thomas one more time. Thomas, are you there? Can you please unmute yourself and try once again? Thomas Redinger.
Thomas.
We don't hear you. I see you unmuted your mic, but we don't hear you. Sorry, Thomas, we're trying. We're going to have to move on to the next person. Alan. Alan, please go ahead and unmute and name, association type, please. Alan? Going once. Okay, we're going to try Blair. Blair, please unmute your mic and ask your question.
I am unmuted. Can you hear me?
We can, Blair. How are you?
Great. Hey, how you guys doing? I appreciate you doing this. My question relates to the authority of boards during this emergency order. Do boards still have the authority to modify house rules? And I'm thinking specifically in light of DBPR 2020-06. And the issue, I'm from Crane Crest Apartments, and we're in Broward County, and we're a co-op. Specifically, can boards modify visitor rules regarding who's in and who is and who isn't allowed, either in the common areas or the units? And what's the legal reference for your decision, for your advice?
Well, when you say who's legally allowed in where?
Well, we're in a co-op. Can the board, does the board have still have the authority to make temporary rules in light of the emergency? And then the common areas and in individual units. So can we say to a unit owner, you can have these kind of people, but not these kind of people in your unit, say immediate family versus friends?
Well, we'd have to examine the governing documents for your cooperative to see the extent of the board's ability to make some types of restrictions as to visitation and occupancy. The chances are that the same type of analysis on any kind of rule adoption by the board would apply, starting with, do they have the authority to do so in the documents? Would the rule be in conflict with other express or implied provisions of your documents? And then is it reasonable? So under the circumstances, is it reasonable to restrict as they're trying to do? Is one aspect that seems like it may be, depending on how far they're taking it. As conditions wind down in the pandemic, it seems that such limitations are being less and less required as people are more involved in the mask wearing, social distancing, and as vaccinations become more prevalent. That may not be as reasonable as it was a year ago or 6 months ago. So they have to be something that's in line with the times.
Got it. Thank you.
Okay, let's try, I don't know how to say this name, Agnieszka, because it's using an older version of Zoom. Agnieszka, your version of Zoom, I'm getting a message, does not work with the mic unmuting. I'm going to move on to Sandra. Sandra, please go ahead and unmute your mic.
Yes, thank you. My name is Sandra Cummings. I'm a board member at L'Ambiance Beach Condominium in Fort Lauderdale. And my question is, what is the legality of age restrictions on using various amenities such as hot tubs and gyms and pools? Can you designate that you have to be a certain age to use it alone, or you have to have supervision, or can you not designate at all?
Hi, Sandra. How you doing?
Good. How are you?
Good. The question is a good one, and the answer isn't simple. It really will depend on the rules themselves. And I think one of the things I'd recommend, and you're aware that any rules you guys are preparing, we should be reviewing with you to make sure because rules should be reviewed by council for two reasons, guys. Number one, to make sure they're enforceable. That you're not putting rules in place which are going to conflict with your documents expressly or by implication. You can't and you're opening yourselves up to enforcement challenges. You don't want rules that are vague that can be interpreted multiple ways. And secondly, that you're not inadvertently, as to Sandra's point, exposing the association, management, and board members to claims of discrimination. And the age restrictions come into play when you're talking about families with children. And there has been, we've had some experience, and there's been some discussions among the fair housing authorities, the county housing authorities that investigate these, that age limitations are going to expose the associations to potential claims for discrimination. So it really depends on how it's worded. And what we're talking about, whether it's whether you're going to be able to, like, what age limit you would put, if any, whether it's an age limit that would be counted with, under a certain age is subject to having to be with a responsible adult, or whether you're able to limit the individual from being there at all. For example, fitness center, or you use the hot tub. I would recommend you review the manufacturer's guidelines on that hot tub. See, does the manufacturer have guidelines that indicate, people under a certain age should not be in there or shouldn't be in there without supervision? If that's the case, then adopting a rule that mirrors the manufacturer guidelines, in my opinion, would be enforceable and should not expose you to a discrimination claim.
Okay, that's good. Thank you. And in our gym, we have something like on the signage, and that's what I was worried about. The signage says no one under 16 allowed.
Yeah, and so I would definitely recommend that rule and any other similar rules be reviewed by your legal counsel so that you can get a written opinion as to the proper way to address those to best protect the association.
Okay. All right. Thank you.
Yep. Good question.
Thank you. Let's try Alan one more time. Alan, can you get your mic working? Your mic is enabled, but we don't hear you. You might have an older version. Okay, gonna have to move on. Nancy, your full name, association type, please. Please unmute your mic, Nancy.
And by association type, he means your position in the association. Nancy, you there?
We're gonna move on.
Muted.
Okay, we're gonna move on right now to Kathy.
Kathy Sidlow.
Kathy, please unmute.
Hi.
Hey, it's Kathy. How are you?
Good afternoon.
Yes.
My question is, we've been informed that a resident has a visitor/invitee who's been staying for the whole season so far, like a couple of months. I'm the president here at Newport H Association down in Deerfield Beach. And I looked in our documents. The only thing addressed is anyone under 18 has a limit of being here 30 days total in a year. There's nothing about a guest or invitee about having been vetted or needing to be interviewed, only the people who own or rent. So how do I handle this? My owners feel that this person who's been here for 2 months should be vetted and investigated and interviewed.
Well, Kathy, you are limited by what your documents provide. And if your documents have no restriction on guest occupancy when the owner is in residence, then people can stay as long as they want, and the association is in no position to do anything about it. What you need to do is amend your declaration to provide for the requirement or limitation of how long somebody can occupy either with or without the owner being in residence before they're required to either leave or submit application for continued occupancy as a tenant, even though there's no rental going on, but your documents have to provide for your ability to do that.
Okay,
No.
and we're in the process of working on our docs as we speak, so.
So that's something you want to add to the list.
And do you suggest, I mean, the person seems amenable to at least doing an interview? Are we protecting ourselves by at least doing an interview, or does this person have to be investigated and vetted? Should we pursue it?
Well, to what end would you be interviewing? What would be your ultimate goal? And what could you do if you didn't like the person or you saw something that was problematic? And there's nothing you really can do about it.
Okay,
Under your documents as they presently stand, so it's probably not a good idea to start that process.
okay, that, at least it gives me, I'm doing my due diligence as the president, and if my owners, I also feel it's somewhat of a little personal problem, because that's what goes on in condos. When people don't care for other people, they look for things. And I'm getting a sense that this might be part of the issue, but I certainly want to make sure my building is protected and I'm doing the right thing.
Sounds good.
That's a good board member. Thanks, Kathy.
Thank you
Jeff.
for my question.
You're welcome.
Thank you. Okay, we're going to try Nancy one more time. Nancy?
And also go back to Thomas. He said his microphone's working. Nancy, you with us?
Nancy, are you there? Okay, we're going to move on.
Thomas Reitinger.
I'm going to see if I can find him. Thomas. Thomas?
Hello.
Hey.
Hey, success.
Yes. Thanks for sticking with it.
I just
Thomas,
called
your
your
name, your
office.
association, and are you a board member?
I'm a homeowner in Cross Creek Patio Homeowners Association Plantation. My question is about speeding in our community. We own the streets in our community, and there's nothing in our documents about speeding issues. And there is some concern because of the rate of speed of some of the people in here that there could be some legal implications of it. And so I'm wondering what the board's obligation is in this regard and what could be the impact to the community if property or someone should get hurt. Hello?
Yes. Well, like there's a couple of things. First, so if you did you say you don't have any rules that prohibit speeding or that indicate that?
In our documents, I didn't find anything that talked about speeding in the community. No.
Right. Okay, because it would typically that would be the kind of thing you'd find in a board, board rule. Although there are certain city or there's certain city or county, even state, potentially state ordinances regarding speed limits in a residential neighborhood. Are there speed signs in the community?
Yeah, the board put up
like 25 mile an hour type signs?
15 mile an hour.
Okay.
Private road.
Just by judging of the rate of speed, there are people going through here at like 50 miles an hour.
It's a difficult, it's one of the more difficult violations to be able to monitor and enforce without really being able to document. Robert, you wanted to add something?
Well, one thing the board can consider is some form of traffic calming device, be a speed hump in the areas that seem to lend themselves to higher rates of speed. There is some city approval requirements when you do that. They're not fans of these things because of emergency vehicle access and things of that nature. Enforcement is always a difficult problem because you have to witness it, and then how are you going to go about enforcing it? It's already over with. You can fine people, but then if they don't pay, then you're in court to pursue that, and it's a small amount, so it's problematic in doing so. So it would seem that the better approach is something that's going to stop the speeding as opposed to enforcing it. And that's something the board should look into various options.
Okay. Thank you.
Thanks, Thomas.
Okay, thank you, Thomas. Next in line, we have Sharif, and I apologize if I did not pronounce it correctly.
Oh, you did it very well. Thank you.
Thank you.
So I put my question actually also in the chat to read it. Basically, I'm a board member in La Palma Association. In brief, we have an owner who had a multi-unit association, which had used his level being a previous board member that alter not only in material, but even in fire extinguisher and sprinkler system in his unit to turn it from 1 bedroom to 2 bedroom, violating all the declaration and condos bylaws, and he did it without a permit and without code. We actually city had put a fine on him. And the question I have, what is the option for the board against him because now it's a health and safety for the building for other owner. I put here the options that I educate myself on, and I would like to hear from you. What is your thinking?
Well, I'd say that the options that you've identified are the appropriate actions to be taken. For those out there who don't see it, it's file a petition for mandatory non-binding arbitration, immediately file a motion to abate the arbitration and take it to court, file a complaint in the court for injunctive relief, and then seek an emergency temporary restraining order on the issues. Whether you qualify as an emergency for this type of situation is the big question. From what you've described, I don't see an immediate imminent possibility of significant bodily injury or damage to property from what this individual has done. While it is a violation, it may not qualify for the emergency type of attention that you are wanting to do here. You may just be stuck with going through the normal arbitration procedure and time frame, and then access to the courts after that if you don't get the relief you're seeking.
So Sharif, as a board member, what you would do in that instance, you obviously want to get with experienced counsel who works in these types of situations, and all the facts are presented, the documentation reviewed, and then it's a cost-benefit analysis. As Robert said, it certainly seems, that you could make the effort to file that petition, spend a few bucks to abate that and go with the emergency injunction. But based on what you presented, I agree with Robert. I don't know that that's going to reach the point where a judge is going to accept that emergency injunctive relief. And so worst case, if they don't, then you've expended a few bucks in legal fees to make that effort and you're back in the arbitration situation. But that would be basically where you'd go about it. And it's a business decision as to whether you want to take that monetary risk.
Let me ask you this question. What do you consider emergency, since this is a situation where you have, he got changed and temper and remove annunciator, put a different fire extinguisher and play with the fire, system in his unit, which is related to life safety in our building. And actually that jeopardized even our insurance.
Right, sure. It's really not, it's not necessarily what we would consider an emergency. It's really what the trier of fact, in this case, the judge would consider an emergency. And I'm not asking you to present obviously presenting the specific facts. That'd be something you get with your attorney, and they would then review those and prepare the complaint. I can tell you, we have done several of these where we filed petitions with arbitration and an immediate motion to abate, and then pursued temporary injunctive relief when you had health safety issues that presented themselves from significant insect infestations or things related from hoarding situations. And we've been successful on getting the judge to agree that that's a significant health safety issue that can't wait the petition, the arbitration process, and should be more immediately addressed. So, it depends on all the facts being presented, and then good counsel will try to put the spin on that to make the judge see that this is a similar emergency. And then it becomes just whether the judge agrees or not.
So you don't have to do it in sequential. You just do it together. That's Like,
Yeah, you would file the petition for arbitration and simultaneously, at least we did, file the petition for arbitration, simultaneously file that motion to abate it, and then you have to get the arbitrator to abate it, and then you'd file the emergency injunctive relief. But that usually is, in our experience, at least the way we do it, is pretty quick.
so what is defined emergency? Like if someone went through the wire, stretch wire type of roofing and flooring, which is in the declaration, you cannot temper and put a hole in it, and he did by doing the new plumbing and moving kitchen and wiring and electric. Is that considered for the court an emergency beside the fire extinguisher example that I just mentioned? Your experience. I'm not asking you to give me a definite.
My inclination is that it isn't, because I'm not hearing imminent possibility of extreme damage to person or property. Threats to life.
Health safety related matters.
Now, these are, but not imminently to occur, meaning it could happen today.
Right. And Sharif, if you were able to, if there was a situation where this person went and did the work and there are exposed wires everywhere, well, that's a whole different story, which is why I was suggesting it's fact-based. And so then those facts would be gathered by the attorney that you work with, and they put together what would be, again, this is if the board decides this is the approach they want to take, you put together an argument that supports your client's position and try to convince a judge that this is an emergency, and hopefully be successful. Again,
how long the arbitration usually take in your experience with DPPR, and is it binding or non-binding?
It's non-binding, and it would take months.
Thanks, Sharif.
Thank you.
Thank you. Next, we're going to go to Linda. Linda, name, association, and your role, please.
Yes, hi, it's Linda Gaddy. I'm with Poinciana Lakes Condominium Association. I'm secretary of the board. I was a former president for about 8 years. And I just want to know how we go about removing a board member. One of the new board members has now called for a closed meeting. He's not keeping the owners appraised of what's going on. And he's had some issues with discrimination against some of our Hispanic owners. So they would like to have him removed and they don't know how. So I was wondering how we go about with that process.
Causing the removal of an owner is
a board member. The board member.
Just from the board?
Yeah. Mm-hmm.
Oh, I'm sorry.
Yeah.
I thought you wanted to get them out of the community.
Yeah,
that might be a good idea too.
Yeah. And if the community is, in general, if there's a board member that the community believes isn't acting in the best interest of the association, then there are either it's at your next annual meeting, people run against that individual and make sure that person doesn't get reelected, or if it's in between, if your election is more than 60 days out, then there is a recall process where a majority of the owners would have to agree that this individual isn't acting well. They don't even need a reason, basically the basis to remove a board member, in my opinion, would be if they're not acting in the best interest of the community and or putting the community at risk, as you've indicated. So that would be the method.
Okay.
All right.
Cool. All right.
Thanks, Linda.
Thank you very much.
And Linda, what you can do is if the majority of the board is concerned, I would reach out to your association attorney and express to them what these concerns are and ask them for further guidance as to what your options are and how you can, short of removing them from the board, maybe address directly with this board member some of these concerns and better way to run the community as the director.
Okay. Next, we will go to Denise. Denise, please go ahead and unmute. I just enabled your microphone. And for those of you in the chat who say you don't see an unmute feature, your unmute feature will not appear until your mic is enabled. Okay, so Denise.
Yes, I'm here. Thank you.
You're welcome.
Hi, Denise.
I'm a board member of Hounds Run HOA, and I have a question about Architectural Review Committee. covenants say they have exclusive power and discretion. And based on that, it appears, based on that, they would not be reporting to the board and asking the board for permission for them to take action, is my understanding. And our insurance carrier for our director and officer liability insurance said that if a committee is not required to report back to the board and they're allowed to act on their own accord, they would need to secure their own director and officer policy for coverage. Has it been your experience that these type of committees, architectural review committees that have exclusive power and discretion, that they would have their own liability coverage? And is my interpretation correct that they do not have to get permission from the board to notice somebody that they're in violation, or they do not have to get the board to agree when they approve or disapprove changes to one's property?
Well, go ahead.
In my experience, having a committee that is not answerable to the board is very unusual. And if your documents are written in that way, I assume that the committee is appointed by the board. So in that respect, the board has some control over how the committee is going to function and how things are going to work. How are they identifying specifications? Is the committee making them, or does the board themselves create the specifications that the committee applies?
Well, unfortunately, we don't have any rules in place. We're in the process of trying to develop standards and rules. That has been a problem in the past, that there's not been consistent rulings. But if somebody's property is in violation, they're not keeping their property up, based on the covenants, since they have exclusive power, they can notify that person that, you know, your trash cans need to be stored away properly. If not, you're going to be fined. So I guess my question is, does I looked up exclusive power. That means they operate independently. Yes, they're appointed by the board, but they have exclusive power, which means they don't have to get permission from the board, nor should they, because they have exclusive power. So is it your experience that these committees don't have their own liability policy? So what if they
think that's a carrier by carrier issue. I don't see why an insurance carrier could not have a rider policy to cover independent committees within the same association, since it is the same association. And it seems odd to me that it's tied to the control of the board over the committee as to whether the insurance policy generally is going to cover them. That seems like it's just an excuse to either not cover or to sell additional insurance. So you might want to shop around and see if there are other insurance providers that might offer something different on this point.
Okay, so it's unusual to give the ARC exclusive power?
Any committee, the board still usually oversees everything. And committees are given certain authorities, and some of it they can make decisions, but the board is still generally the ultimate responsibility and in charge of how they function.
Okay, so then
I just would ask Denise, if the ARC is made up, if the majority of the ARC is made up of directors, which in some communities they are.
It's not, they're independent.
Right, okay, then that would be more, that would seem to fall under the advisory committee under chapter 617. And to my knowledge, to my recollection, an ARC is not an exception to that language in 617. So
we're an HOA.
Yeah, chapter 617 is your Florida not-for-profit statute, which does apply to HOAs, condos, and co-ops.
Okay. So to avoid getting extra insurance, then you can tell them that the board has to approve everything they do.
Well, again, the insurance related issue, and again, this is a question, and Robert may have said this, I missed it, you should certainly be speaking to your insurance agent. I mean, insurance, anytime you have a question, a good question that refers to, hey, insurance coverage, you certainly can run it. Experienced counsel will be able to offer some guidance, but in my opinion, one of the best guidances I give my clients is, hey, you have an agent, the agent is available, and meet with your agent and ask these questions and get responses in writing from them as to coverage. Generally speaking, the directors and officers coverage does cover committee members, but you'd want to confirm that with the agent.
Right. And the agent said if they're not required to report back to the board and are allowed to act on their own accord, then they would need to secure their own coverage. And so it all comes back to exclusive power.
Yeah. When you say secure their own, coverage, you mean the association would then need to have separate coverage for them.
Correct.
Okay.
So a solution would be that 3 board members serve as that ARC.
Well, how many members are on the ARC?
3.
Then again, if 2 of the 3 were board members, then it is then that's fine. It's just as long as a majority of the committee members are made up of directors, then that's more in the form of an executive committee versus an advisory committee, and that committee can be delegated authority to act as if they were on behalf of the board, with limited exceptions.
Okay.
And the ARC approvals is not one of those exceptions.
Yeah. The issue you run into, I'll be real quick here, is if the ARC makes a decision that's arbitrary and capricious, and then the board is sued for that decision. So that's
the board wouldn't be sued, the association would be sued.
Well, yeah, the association would be. So yes, correct. You're right. Okay, thank you.
Thank you, Denise. But to Denise's point, I mean, I think it's not uncommon that you have independent ARC committee members who are given the authority in governing documents to adopt rules and then to make the determinations on approving or disapproving of the ARC applications. So it's something that needs to be vetted. Again, if you want your documents vetted, reviewed along with this chapter 617 language, which was a change in the statute in 2020, by the way. So this is sort of new. And so go to your legal counsel and get guidance. And if you don't have good legal counsel, then I might know one. So next, Jeff.
Okay. Linda, your mic has been enabled. Please unmute yourself and state your name and association and your role, please.
Linda Garfold, that's me.
Linda, hi, Linda. What community are you with?
I'm with Stratmore Gate West. I'm the president. We're in Royal Palm Beach. I have a question about executive committees. I see that you can have them if you're a nonprofit or an HOA, but how would I go about establishing an executive committee?
Well, the first thing you have to look at is how your bylaws are structured on this, because typically there's guidance in there on whether the president can do it or whether the board would have to do it. And that's your first step. And once you've determined who's the agency within your community to establish the committee, then you follow those procedures.
Okay, our governing documents are about 40 years old. They need rewritten, and they don't address executive committees anywhere.
There's no mention of committees in your bylaws?
Not executive committees. I mean, we have an architectural committee, we have a landscape committee, we have a resale, and
well, in the absence of express provisions for the president to establish an executive committee, then that would have to be done by the board, majority of the board.
Okay, thank you.
Sure.
Thank you, Linda. Okay, next we will move to Janice. Janice, your mic has been enabled. Please unmute yourself, name, association, and your role, please.
Hello, I'm a homeowner, and we'd really appreciate
what community,
advice.
Janice?
I'd rather not say.
But we need to know because we may represent them, and that's important information.
I need to bring Janice back. Little slip up here. Hang on. My apologies, Janice. If I can find her. There we go. Go ahead, Janice. My apologies. Continue. Please unmute and continue.
Okay. Our issue is that for a long time, our community it's got a particular name. This name is replicated in other communities, and the name is replicated on the private Facebook owners page. Recently, the community have trademarked this particular name, so they've now sent the administrators of the Facebook page a letter basically saying that they feel they're breaching the trademark name. So our questions are that the page has been in existence a long time. It is the name of the resort followed by private homeowners. Admission to that Facebook page is homeowners only. They're verified owners. The rules of the Facebook page state there is no HOA affiliation and there is no marketing. So bearing that in mind, can the HOA put an order in place that we are breaching the trademark and we must not use the name of the resort within the title of the Facebook page, even though it's followed by private homeowners' Facebook page?
Well, the general purpose of acquiring a trademark is to protect your name and gives you the ability to do so through legal means. So what your group has the choice of is either acquiescing to the demand you've received and change the name in a manner that satisfies this resort community relative to their trademark, or you can find yourself dealing with potential legal actions and having to defend and convince a court that your argument is the one that it should adopt. And whether or not that happens, it's really on a case-by-case basis, hard to predict. But you'd be looking at significant financial outlay just in trying to defend your position. So it seems the prudent course would be not to get into such a fight, but that's something that I guess you all would have to decide.
We certainly don't want to be getting into a fight where there's litigation and money involved.
Okay. Thank you, Janice.
Thank you.
Thank you, Janice.
Okay, Jeff, let's go rapid fire, guys. We want to get as many of you in the next 20 minutes as we can.
Our next question is from George. George, please go ahead and unmute.
Hi,
Yes,
George.
good afternoon. First of all, thank you. George Molnar, HOA's Country Creek, Village of Estero, Lee County, over on the other side of the state.
Welcome.
I have not kept up on what are the emergency requirements the governor has placed, nor what the DBPR interpretation of those are. But we have an HOA annual members meeting coming up in a couple of weeks. And I just have a couple of questions about it. Can we do it totally virtually? And do we have to have a physical location for those people who can't attend virtually? And we have somewhat adopted the condo form of voting in the sense that we had to have all of the nominations put in 40 days before. So there's no floor nominations. But my concern still is, how do we handle proxies? Both proxies for the meeting, proxies for voting, and proxies for, we are also adopting changes to our governing documents. I just don't see how we can possibly handle those. And we do not have electronic voting. So I don't know how we can handle voting. Anyway, thank you. I'll shut up. And thank you, guys. You do a great job.
Thanks, George. I get. Although stick around, because my question is, well, I don't want to answer a question with a question, but you're saying, how do we handle proxies? I mean, with a virtual meeting. I mean, the way what I've seen is proxies are remember, with a proxy, it's especially like voting on amendments, it's different if you're able to vote via proxy. And by the way, whether you can vote that way in an election will be document specific. In the HOA, you certainly cannot in a condominium setting. But the proxies can be mailed, can be scanned and emailed, can be faxed, can be dropped off. And so if you're holding this, if the meeting is primarily being held virtually, but there is a location, either a management office, management company's office, or maybe an office on site, that's where these proxies should be delivered, and they should be said to be delivered by a certain time in advance of the meeting. So in order to then be counted for that meeting. So that's how proxies would be handled. I don't know, Robert, if there's something that I may have missed on that particular part of the question.
I don't think so.
Okay. So that's how, and there are many communities that are doing meetings virtually and doing it in that regard. With regard to elections, and I've actually attended a few more recently where the meetings are virtual. The in-person aspect of it is in a very large room where the limitation is to the inspectors of the election. If there's an election monitor, a representative of my firm to assist the legal questions, the candidates themselves, and representatives from the management company, assuming there's a management company, and those have been the only ones in the room. And then there's a virtual showing to anyone who wants to be watch, and all the verifying of the envelopes, the tallying of the ballots are all done in front of the cameras with multiple volunteers in person, but masked and limited. And that seems to have been successfully handled as well.
Okay, well, thank you. But again, my question very simply is, do we have to have a physical location for people, for whatever reason, who cannot or don't want to vote electronically, participate electronically, whatever, show up and simply, check names on the ballot and throw it in the ballot box? I mean, I hate to say it, but that's the American way of voting.
Yeah. In my opinion, there has to be there is a physical location, because somewhere these ballots are showing up, these proxies are showing up to be counted. So wherever that is, like I said, the management office, the association clubhouse, maybe the attorney's office in certain instances, I don't know, that would be the quote physical location. And so owners would be informed that they would be informed the meeting is being held virtually. You can deliver your votes in these ways, including dropping it off at this location.
Well, thank you. And then one follow-up, if I may. I know you, neither Michael nor the other people are old enough to remember the old Helen Thomas, but I'd like to ask one follow-up question. We are also voting on a total change to our governing documents. This is an HOA, declarations, articles, bylaws. But we've had several meetings, several Zoom meetings where an attorney, unfortunately not your firm, but an attorney has gone over these things and people have asked questions. But every Zoom meeting has ended with, well, thank you for all of your comments. We will take them into consideration and discuss them with the board. But there is no plan to send out the actual copy of the documents that we will be voting on at the annual meeting to significantly amend. The board says, well, after it's voted on, we'll send you a copy. And I say, this sounds too much like Chuck Schumer and Nancy Pelosi to me. Don't they have to send us a copy of exactly what we're voting on?
We're going to leave politics out of this, George.
Well, some politics, not
some politics, but right. The answer to your question is, anytime that you're submitting, you're asking the membership to vote on amendments, whether it's a single amendment or a rewrite, yes, the amendments themselves need to be sent out in advance to the membership, either with the new language underlined and old language stricken out, or in your example, if it's a complete rewrite, there can be just the proposed new documents sent out with a caption on the top that says something along the lines of, this is a substantial rewrite of the original documents, see the original documents if you want to compare the old language. But those need to be sent out along with the proxy that you're voting on. They can't just send you a proxy and ask you to vote without telling you what you're voting on.
Thank you. And again, my last question is,
George, you're asking too many. You got to get a circle around to the.
Now, who's holding up the Stanley Cup in the background?
Oh, that's going to be Detroit.
That's Scotty.
Scotty Bowman, Detroit.
No, Scotty Bowman was the Canadiens. He was never Detroit. Scotty Bowman was the Habs. Thank you.
Goodbye, George. Thanks again. Jeff, who's next?
All right, next we have Don. Don, please unmute your mic.
Hi there. Thanks for taking the time. Appreciate that.
Hey, Don.
We're Cypress Lake East number 5, 16-unit co-op, Pompano Beach. I'm the president of the board. Our building sits on leased land, and I've read Florida statutes that said the leaseholder, we would have right of first refusal should our leaseholder decide to sell. Are there any other statutes in Florida law that you know of that would tell us or make certain things happening at the end of the 99-year lease?
Does the lease itself have provision for what happens at the end?
Other than the ability to renegotiate it, I didn't see anything.
Yeah, unfortunately, some of the leases from the early days when your cooperative was created didn't take into account a turnover of the property to the cooperative at the end. It makes sense under your circumstances at some point to attempt to negotiate a buyout of that lease on terms that are going to be favorable to you, so that at the end there isn't a question what's going to happen. And it could end up that the buyout is for the same amount that you're going to pay it anyway, but it clarifies, or perhaps the landholder will agree to some form of an amendment to your arrangement to clarify on that issue. But there is no statute in place that says it's going to go this way or that way. It's all based on the documentation itself.
Thank you very much. It's just doing a little planning ahead. It's still 46 years off, but we do offer to buy it every year. Thank you.
Okay.
And Don, yeah, that's something that certainly, if that's something you're looking for assistance with, you can get with your counsel and they can assist.
Okay, thank you. Kathleen, your mic has been enabled. Kathleen, please unmute yourself. Name, association, and your role, please.
Thank you. My name is Kathleen Byrne. I'm the Vice President of the Board of Governors for Sky Harbor East in Fort Lauderdale. I was originally going to ask a different question, but this relates to ADA compliance. Our condo was built in the 1960s, and we currently have no handicap parking. Our lobby has some steps in it, so we have limited handicap access. We also have a significant parking problem. We're considering expanding our parking lot. If we choose to do such a thing, would that force us to then build in handicap parking into that new lot? And would our entire building then be subject to current ADA regulations?
Well, I mean, I'll start. It's based on the limited fact pattern that you presented, Kathleen. It's my understanding that if you are going to do renovations, if you're going to undertake work that you just described, it would require ADA compliance. And when you would submit, obviously it would require permit approval for the work that you're doing. And my understanding is that you would be required as part of that process to become ADA compliant. Prior to that, you know, because we get this question a lot. Hey, we've been told we don't have a handicap parking, or we don't have such and such. And you don't, if you were built prior to, you don't have to become ADA compliant. You don't have to address certain things to become ADA compliant. But once you touch, and not just, you know, simple maintenance, but once you touch to do something like you described, that is going to, my understanding is that would require you then as part of that project to become ADA compliant. Robert, do you have anything else?
No, I think you hit it all.
And that would, I'm sorry, one more question. Would that include then making the interior of the building also ADA compliant, or just the parking lot?
Again, if you're just addressing the parking lot, again, my understanding, it would not necessarily impact the interior of the building. But that would certainly be something that would be flushed out as part of the process. When you're going through that process, obviously I would hope you'd have a consultant. You'd certainly want to have experienced counsel working with you when you're reviewing these contracts and these requirements to make sure T's are crossed and I's are dotted.
Thank you very much.
You're welcome, Kathleen. Thank you. Next.
Thank you. Next, Philip. Philip, please unmute yourself, name, association, and your role.
Yes, hi, my name is Philip Kinty. I'm a board member of a co-op. It's the Virginian Apartments of Pompano Beach. And we have a board president that's been very tyrannical and bullying and disrespectful to everyone, board members as owners alike. And many of the owners have asked me to start a recall. My question is, the pages of the recall are so complicated and so long. I know there's a 60-day allowance. If I were to submit 10% of the board or the owners for the recall petition, do I do it now or do I have to wait till after the 60 days?
The better approach on recall in our experience is the written agreements as opposed to 10% to call a meeting. Either way, you can't do it within 60 days of the annual election, either side of it, either 60 days before or 60 days after. So from a timing perspective, that's what you want to keep in mind.
Sure. And as far as the getting the petition signed and everything else, that also has to be given to the secretary, and the secretary has to send that to all the owners. So as long as the vote is not counted after the first 60 days of the board being formed, is that fine? Can I start the process now, or do I have to wait for 60 days before I start the process?
You can be processing, you just can't deliver it.
So I can't deliver it to the secretary to be sent out to the owners.
What are you talking about delivering to the owners?
Well, yeah, our
Notice
bylaw
the meeting?
says that when we do a recall, you do 10% of the owners, and then it's submitted to the secretary, and the secretary is responsible for sending the final vote to all the owners absent or those who are living on site.
The 10% your process you're talking about is to ask the board to call a meeting of the owners for the purpose of considering recall.
Yes, that's correct.
And that should not be delivered to the association either within 60 days before the election or 60 days after.
Got you. Very good. Thank you. That's all I needed.
All right. Good luck with that.
Thank you. Okay, our next caller in the order in which they are received is John. John Burns, please go ahead with your name, association, and your role.
My name is John Burns. I'm with the Venetian Condominium in Fort Lauderdale, Florida. My question is on disaster plans. We have the typical fire emergency plan. We have our hurricane checklist, things like that. But we've been challenged by an owner who said that our disaster plan perhaps isn't as robust as it could be. It doesn't include active shooters. It doesn't include hazardous substances being delivered in the mail. It doesn't include bomb threats and things like that. My question to you is how imperative is it for a board to have a robust disaster plan? And a follow-up question would be, normally when our building empties for hurricanes and people leave, not everybody leaves. Some people just choose to stay. And those people that choose to stay often sometimes run around and are very helpful in terms of leaks and things like that. What liabilities does that generate for the board?
Well, as far as the disaster plan, I imagine you don't get too many of those other situations that you described. It's a business judgment type of a situation for the board to make when it comes to, you're not going to be able to adopt something that's going to cover every possible situation that may occur. You're going to focus on the things that are more likely to occur where we live, hurricanes, natural disasters. Nobody thought in terms of a pandemic, so nobody was prepared for that. You do the best you can. You don't expect to cover everything, and you make your reasonable business decision, and that's generally upheld by courts to any challenge, as long as it's reasonably based. The other question you had to, if you could repeat that,
is if there's a mandatory evacuation of the barrier island and some people just simply refuse to go, and of that subset that decides to stay, sometimes they have been very helpful with monitoring the building during the storm when the staff is not here?
Mhm.
Are there liabilities created by homeowners who stay behind and, try to keep water from coming in the doors or try to board up a window or those kinds of things?
I have never seen anybody brought under any kind of liability for that. Possibly if they're injured in the process, might they bring a claim against the association and or its insurance carrier for the injury? It seems unlikely because they put themselves in that position, as opposed, since there was a mandatory evacuation order that they chose to ignore. That would tend to mitigate or temper any kind of exposure the association would have for any damage that they may claim. That doesn't mean there won't be any or there won't be a claim made. And your insurance should be able to address that in the event that it occurs.
Thank you.
Thanks for listening.
Thank you, John. I think we have time for one more. We're coming up on the top of the hour, on 2 hours here.
All right, we can take a couple more, Jeff.
Couple more? You got it. You give the word. Ginny, I am enabling your mic.
Yes, I understand that the parking lot, I'm sorry, Ginny Vaughn, I'm with Colony Point Condominium, and I'm the treasurer. And, the parking lot is a common area, and in my opinion, you're supposed to wear a mask. It's mandated to wear a mask. Is that even if you're by yourself, which means you are socially distant?
By yourself in the common areas?
In the common area, in the parking lot.
In the parking lot, outside or underneath?
Yes, outside.
Well, it really is. It's not a state or it's not a county mandate. It would really be with the board, what the board rules are.
Okay. Okay.
No, and I mean the board and the rules are reasonable. And so if the board has adopted rules that requires that you're have facial coverings whenever you're in the common element areas of the community, then a mask should be worn in the parking lot until you get into your vehicle.
Okay. Thank you.
You're welcome. Thanks, Jenny.
Thank you, Ginny.
Next.
Our next question is from Patty. Patty, your mic has been enabled. Name, role, and association, please. Please unmute yourself.
And while
Patty.
Patty's unmuting herself, hi Patty. Just Patty, one second. I just want to let that there. I know there's a few of you who have typed some questions in the Q&A, and obviously there were a lot of attendees, and you have a lot of good questions. And as you can see, we're trying to get through as many of them as we can. Before Jeff closes this out, I'll try to take a few minutes to answer a couple of the Q&As. But unfortunately, we're not going to be able to get to some of these questions. I encourage you to reach out to your association attorney to ask these questions. If you don't have one, again, certainly you can search for one. We will have future programs, and we would encourage you to try to get to those and let us know about that you were missed on this one. We'll try to get you up front on that one. All right, next.
Patty?
Patty Resch, and I'm from Oceana North 1 condominium. We had a manager for 32 years, and my husband started a web page. We were then got a management company that came in July of 2019. They refused to release the names to our owners who would like an owner's list. What can we do about it?
Okay.
You're saying an owner roster that is
Yes.
part of the official records of the association. They're refusing. I mean, it's a statutory requirement.
What you need to do, Patty, is you need to make a written request to inspect the records. And as part of that, you can say, I'd like to inspect the records. Specifically, I'd like to inspect the roster. If you prefer, you can just send me a copy. And then at that point, they can either send you a copy or they're supposed to respond to you within 10 business days, giving you access to the records, at which point you can review and make your own copy of the roster. If that doesn't occur, as with any other, and I speak in general now, if you make a proper request to inspect records, association, board members, managers, I implore you that if you're not sure, reach out to counsel. Otherwise, you need to give that individual access to the records in the way they're kept. You do not need to cull through records to try to find what they want. In Patty's case, she's asking for a roster. That's pretty simple. My advice to my client would be, hey, you don't want to set a precedent of giving out documents, but handing someone a roster might be pretty easy. But Patty, if for some reason they're refusing, then you need to contact you can contact the compliance division of the DBPR and let them know that you were denied, and they can address it. You also can file an action for arbitration that they willfully withheld documents, and the association could be exposed to monetary penalties, which is why I tell associations, do not deny access to official records.
Well, I had asked the association to give me 100 copies of the roster, and the manager said to me, well, I don't think I have ink, I don't have paper. He ultimately did it, and I passed it out to some owners who
Right.
took
Well,
offense.
Patty, and I apologize for cutting into your, I just wanted, because I passed one, I'd like to try to get a couple more questions, but I just want to let you know what the manager did there for you, they did not have to do. Nobody has to make even a single copy for you unless you go in and inspect, and then you can get a copy. And if you're saying, hey, I want 100 copies, they have the right to say, well, that's 25 cents a page, Patty. If you want to pay $25 for the 100 copies, I think that's the right math, then we're happy to give it to you. But if they gave you 100 copies as a courtesy, that was over and above their obligation.
Okay, thank you.
You're welcome, Patty. Thanks. Next, Jeff.
Okay, next we have Kathy. Kathy, your mic has been enabled. Please unmute yourself. Name, association, and role.
Hi, my name is Kathy Harris. I'm the document committee chair at Vizcaya. And I apologize for the length of this. It's not too long. It regards pavers. From about 1990 to 2000, owners put in pavers directly outside lanai exits on common property that are very obvious. And the board did nothing to stop it. And it was contrary to our rules then. Now, recently, and this is important, in the last year and a half, some owners have gone way overboard and put in not 4 to 10 pavers, but rather large patios and very long walkways outside these same exits on common property, very obvious. From one of your articles, we do understand that we have to send all the owners a letter now saying in the future, the board will enforce its rules against putting pavers on common property. But more importantly, we want to issue guidelines, the board, that says you can put in these pavers loose on ground, maybe packed together, not in concrete, on common property in a certain size, certain configuration, and with certain approval mechanisms. And we want to tell the owners that put in these very large, oversized patios recently that they have to reduce them to the size of our new guidelines, the ones I just mentioned. So my question is, can the board establish such guidelines for the future and require reduction of these very large paver settings on common property to these guidelines?
Okay, well, I'll start, Robert. Real quick, Kathy, here's my opinion on both. And Robert, if you have anything more to add, please jump in. Guidelines, when you're talking about guidelines, architectural type guidelines, not only can you absolutely should and must. If you want the ability to be able to tell owners, and again, this presumes, listeners, that your governing documents give this type of authority. So presuming that, then you absolutely want to have guidelines in place, specific guidelines, size, material, location, color, all of those things need to be specifically spelled out, and they should be properly adopted at a board meeting. And because you're addressing either a unit or a parcel, that's a 14-day notice of that board meeting that you're mailing to all owners and posting where the agenda indicates that these guidelines or rules are going to be considered. You don't have to include them with the mailing, but you do have to at least notify them. And then you have to adopt these guidelines, these specific rules. So that's a must. You absolutely must. But rules cannot be applied retroactively. So if you didn't have rules in place and people put in certain size patios and there was nothing that you could claim they were in violation of at the time, to adopt a rule and then try to retroactively apply it, you could run into a successible legal challenge. Robert?
Just to clarify, we understand that. Mm-hmm. And the difference is the older 20-year-old ones are small. We realize we can't do anything about them. We're going to send the notice that says nobody can put in pavers unless they meet these guidelines.
What we want to do, though, in the last year and a half, and we've been dealing with it for this length of time, is say to them, you can't have these extra large sizes, which are very different. About 8 of them exist, than the 200 of the small little ones. You cannot have these. You've got to reduce them to these guidelines. We always had a rule that owners could not put anything on common property without board approval in writing.
And do you have board approval in writing of all the other ones?
No, the board just let it go for years. We realized that we can't do anything about the old ones. It's okay. We're going to correct safety issues in those. You know, a few of them are raised. They cause a tripping hazard. They're just on the ground. So we're going to correct those, let them go, correct the safety issues, and tell the new installations that are much larger that they have to reduce them to these guidelines.
And
We see our option as either telling them to take them out completely. They put them in without approval, contrary to our documents and rules, that they couldn't put anything on common property.
But not to your conduct.
Pardon?
It may be contrary to your documents, but not to your past conduct. So that's a problem for you. And you say all of this is common area, even the small ones?
The small ones are all on common area. They're all public. They're obvious. They're right behind exits. People put them on these exits to get over mud to reach the grass. The mud was a problem.
Well, being that it's common areas, it's still within the control of the association. So
Yes.
if the board chooses an option, an aggressive option would be for the board to reduce any of these larger ones to the size that's it's going to allow at the expense of the association, and to restore the area to its original condition, since you're unable to force the owner that did it to do it themselves.
I'm sorry, I didn't quite understand that.
So
the owners who put the big ones in.
They put big ones in, and you're saying they're big pavers or covering larger areas?
They're covering larger areas, much larger areas. The patios attached to their.
Because of your past conduct and not requiring approval and not having specific limitations on how large they could be, you would have a difficult time pursuing legal action against the larger, more recent ones, because they're there before you changed your procedures. But it's still common area, and that's under the control of the association. So rather than forcing the owner to remove them and restore it, the association can remove the portion that's too large itself and restore the area to the grass or whatever was there before, at the expense of the association. It would not be an enforcement action. It would be just maintenance by the association.
Okay, and then could they then put in a smaller paver pad consistent with the guidelines that we'd pass at this 14-day meeting, 14-day notice?
You wouldn't necessarily remove the whole thing. You just remove the portion that's too large.
I see. Okay, and that would be after we have this 14-day meeting establishing the guidelines. Is that right?
Yes.
Okay. Thank you so much. You guys are great.
Thank you.
Thanks,
All right.
Kathy. Appreciate it. All right, let's try a couple more, and then we're gonna say our goodbyes, and we're gonna thank you all for being here. And again, you know, we're sorry if we couldn't get to everybody's questions. As you can see, we're doing our best. And hopefully, if we can help you as a firm down the road, you will consider us. Jeff,
And we'll
let's
do
try
this
two
again
more.
sometime.
Okay, a couple more. Alberto, please unmute your mic.
Yes. Hi, can you guys hear me?
We can.
Yes.
Okay, great. So my name is Alberto Lucarelli. I'm with the Meadowbrooks building number 10. And I was actually just recently nominated by the board to be an officer. So my question was, you know, how long can a person be entitled to be on the board in terms of like how many years are they allowed to? So from some of the stuff that I've been reading, it sounds like it's 8, but I just wanted to make sure, you know, what's the maximum amount of years that a person could be part of the board?
Well, for condominiums, the statute provides for a limitation of 8 consecutive years starting July 1, 2018. that's when the clock started ticking based upon the effectiveness of the statute.
Okay, so that means,
Anyone who was on as of that date can continue to serve until July 1 or June 30th of 2026.
okay,
There are certain exceptions that the statute allows, such as 2/3 of the owners vote in favor of that individual continuing, or there being insufficient number of other candidates.
okay, perfect. And how many, so typically, how many members should be, so we're 72 units. What's the recommended number of board members? Is it, some say 5, some say 7, just?
There is no specific recommended number. Your documents may provide for a range or a specific number. You'd have to go with that. If it says 3 to 9, then the board can choose 7 or 9, or however it's established, either the board or the members will be indicated in the documents themselves. But it really comes down to what works best for you. Generally, smaller tends to work better than larger because you get more done, but sometimes you don't get the representation that you need. So it really depends on your circumstances and what your documents say.
Okay, and
It's
one
best
last.
to keep it an odd number no matter what.
Yeah, okay, thanks. Yeah, that's a given. It's always an odd number. One last question, and I'm trying to be quick because I want to be respectful for others. Is it, so I've been part of this building since 2012, and we've never had a management company. Is it highly recommended that we get a management company to also, I mean, a lot of the board members are volunteer, right? And it's a lot of work for the board members. So what's the ratio? Is it like, 90% of the condo owner associations are with management companies, or are they running it themselves?
I don't think anybody's kept track of that as far as the percentages, but I'd say a good number of them could even be a majority, but it's really the circumstances within your own building that are going to dictate that need. As you say, volunteers have limited time and ability, so that's the reason that many go to professional management services, to take some of these requirements off of them and put it into the hands of those professionals that do it on a regular basis. It also provides some insulation of the individual board members from unit owners that are wanting to knock on their doors at all times of the day and night because they have a leak in their kitchen or some other type of problem that you don't want to necessarily have to deal with on a face-to-face basis. You go through a more formal process with the management company.
Okay, perfect. Well, thank you so much. I really appreciate the answers.
You're welcome. All right, Jeff, who's our last lucky one?
L. Culpepper. And you're using an older version of Zoom. Hang on a second here. I'm gonna have to, this will not work, unfortunately. Your version of Zoom is not compatible. I'm gonna have to go to Cindy. Cindy, go ahead.
Thank you. This is Cindy Kushner with the La Ambiance Board. I'm the treasurer. And this should be quick. My understanding is that pre-board meetings are prohibited by the Florida Sunshine Laws. So 1, is this accurate? And 2, are there suggestions on how the board can operate effectively, with having these, without having the ability to have pre-board meetings?
Hi, Cindy. How are you?
Good, and thank you, Mike, for everything you have been doing for us.
You're welcome. So I just want to clarify for everybody, the Florida Sunshine Laws, as you mentioned, those are not applicable to community associations. That's a situation that applies to municipalities or quasi-municipalities like a recreation district or a CDD. So your condominium association isn't subject to Florida Sunshine Laws. There are certainly Chapter 718 as well as 719 and 720 do have certain limitations and certain intentions in the statutes, which require when board members are conducting business, which is not specifically defined, but in our opinion and based on recent changes to the statute means when the board's taking action, motions, etc., those need to be done at properly noticed and open meetings of the board. But to use your words, a pre-board meeting where board members are meeting to fact gather and address in that regard, our opinion is that isn't something that necessarily is considered an official board meeting. That said, I mean, I don't know that if someone in the building said, "Hey, why is the board, having this conversation?" There's, the quorum of the board is all standing around and they haven't noticed the meeting, and complain to the division if the division would necessarily agree. But, there's been recent changes in the law that specifically say that board members can communicate by email. You just cannot vote by email. And that, to me, that codifies the situation that, yes, board members it's not practical for you to have to sit down at a table and try to make all your decisions sitting at the table. There has to be some ability to have pre-board meetings, whether they're by email, if you can email. I don't know why you couldn't text. I don't know why you couldn't all be on a phone call or even standing around, my opinion. I just think it's important that the intention of the statute is clear. Decisions of the board should be made at properly noticed open meetings of the board where the membership is in attendance. And if there has been, email discussions, for example, on these matters in advance, before you vote, that the summary of those discussions be presented to any owners present rather than just a rubber stamp. To me, that is in compliance with the statute and the intent of the statute.
Perfect. Thank you very much.
You're welcome. All right. I think, unfortunately, now we're at 1:20, and as much as I'd love to be able to take everybody else's questions, I think we're going to need to wrap up today, and we will do this again. We'll try to see if we can get another one scheduled next month. I want to thank you all. We want to thank you all again for attending. And Robert, you want to add anything more before we say goodnight or good afternoon?
All good questions today, and we look forward to the next time to get together and try this once again. Stay safe.
Yes, everybody stay safe. Thank you.
And there'll be a brief survey as you as we end the meeting here. That'll pop up on your screens as we end it. So thanks once again, everybody. Stay safe out there. Be sure you're on our mailing list. If you're not, visit kbrlegal.com and fill out the form at the bottom of the page to be sure you get our emails with all of our upcoming events and activities with the firm. Thanks so much, and have a wonderful day and an even better weekend. Thank you.